Good afternoon, everybody. Thank you for, or morning, actually. It is morning. Still, it feels like afternoon. I apologize. I'm Chris Body. This is Paul Morrison. We're from Body and Morrison. Welcome to our Planet webinar on capital gains. And so Paul's going to explain to you how this is going to go this afternoon, and we're going to be here together doing this presentation with you. Using for the first time ever PowerPoint.
We've always thought PowerPoint was a crutch, and we never used it in our live workshops. I don't know if you guys may not know this, probably don't. At Body and Morrison for 20-something years, our bread and butter was hosting live workshops where we educated folks about estate planning.
Right.
And we had a presentation that over time grew naturally, feature creep, got a little down, but we were jamming in a lot of knowledge. We had a good time doing it, and we've taught thousands and thousands of people a lot about estate planning. And so many of them became our clients, many didn't. But we're out there trying to spread the word. Now, what happened in COVID, obviously, meant we had to cease live get-togethers and workshops. So we pivoted to the webinar model. And fortuitously, about maybe 2 years ago, we had a videographer come in and record one of our live workshops. And fortuitously as well, Chris's brother happens to be a filmmaker, top-notch, awesome, Middletown, look it up. And so he was able to edit that thing down to a more reasonable length by cutting some parts out. And you know, we were thinking, we didn't know what to do with it for a while. We hadn't edited it until COVID hit, and we said, hey, we got this presentation sitting there. Let's break it out. Let's dust it off. Let's tighten it up and put it out there. So we use that now as a webinar, the basis of our evening webinars. Those are the full length 2.5 hour ones where we talk a little bit at the beginning, hit play on that presentation, and then come back at the end to answer questions, because just as today, evening workshop or webinar attendees have the ability to chat questions to us during the presentation. Now, some of the pieces that got left on the cutting room floor, though, are still worthy of discussion. And one of those topics happens to be what we're covering today. And so what happened when we condensed it, we cut out one of the parts of the discussion about a really cool tax technique that is generally unknown to people, and thereby you guys are in danger of just walking away from it and leaving it on the table. And this is the ability to completely eliminate capital gains tax on any asset. This technique works on anything, okay? Your residence, rental properties, racehorses, bars of gold, shares of stock. And we took the thing that I do on the whiteboard at the presentation, and Helen, our webinar guru and all-around internet maven, shout out to Helen. I know she can't be watching now. She's teaching some other class. But anyway, she's getting us really moving in the direction we had long contemplated, but really got pushed in that direction because of COVID. And so now we're doing we have a much bigger online presence. We are posting blogs regularly. There's a lot of content on our website. You guys should go check it out. We each are contributing articles that we write every couple of weeks to there, so there's always something new. Keep checking the website. You can register for the evening webinars. And then what we decided to do to just touch on one topic every week or two, we have this series of daytime webinars we call Plan On It. And today's topic in the Plan On series is, as I said, this discussion about capital gains. Now, we had long looked down upon presenters who rely on PowerPoint, because at our workshop we went all live and it was really coming from the heart. We didn't rely on those types of crutches. But since it would be really goofy to do it on a whiteboard here and have you guys try to follow along, Helen helped us out and converted that workshop, the workshop whiteboard method to a slideshow on PowerPoint. Now, this is our first run through with a PowerPoint.
No pressure.
Yeah, appended to our webinar discussion, but we're going to get that going right now. Yep. And as let me back up. You're right. He's here to help me say.
That's where we're tag teaming each other.
Yeah, and we have that approach in our live workshops too. We take turns talking about different topics. This topic happens to be one of the ones I cover, so I'll be doing most of the talking here today, but Chris will keep me on point. And it's weird because we're taking a portion of the workshop, just cutting it out of there and dropping it into a void here today with no lead up to it, which there is a considerable amount of that in our live presentation. And so what this is really about, we talk quite a bit.
Get to the lead up, though.
Yeah.
I just want to say about the chat feature.
Oh, yeah.
Okay, so it's when you send these chat messages, questions basically to us, they're private. So in other words, your question only shows up on our end, and it doesn't show up for the rest of the people out there. And we know there are people out there, by the way. We can tell. And so don't be shy about asking those questions. And I'm not sure if we'll interrupt the presentation or save them for the end. It depends on the context of the question.
We'll see how it goes. Okay. We'll see how the flow's going. If I implode and I need to take a break from the slideshow or something happens, we will go live with those questions, but we might just store them up until the end and address them then. But so at the workshop and the evening webinar, if you've been to one, we may have some folks attending who have already witnessed our webinar presentation, or if you want to jump into one, I think there's one next week. We talk a lot about forms of ownership, and one of the forms of ownership that we talk in depth about is joint tenancy. Now, joint tenancy happens to be the default form of ownership that our system just kind of herds co-owners, especially married co-owners, into. And so at the workshop, we discuss the pitfalls and some of the problems that joint tenants can run into, with the ultimate problem of joint tenancy being eventually that string of co-owners that are joint tenants is going to run out, and that asset, the house typically, will end up going into probate. So joint tenancy is not an effective probate avoidance device ultimately, and there's other problems with it too. In fact, one of the blog articles that I wrote and is posted on our website is strictly talking about joint tenancy. So you can go check that out if you want a little bit more backstory on what joint tenancy is all about. But the tax treatment that we're going to explore today that allows us to completely defeat capital gains tax is derived from another form of ownership that we as Californians have available to us just by random luck, because we live in one of these 9 states. There's only 9 lucky states where you can own things as community property. Now, we know community property has a little image problem that's largely derived from the divorce context, because you hear these horror stories about divorces gone wrong and somebody losing half of everything because of community property, stupid community property. Well, in our world of estate planning, one of the reasons we love what we do, it's really positive. We have happy people for clients, really rare among attorneys. And so the same rules that govern community property that sometimes lead to seemingly unfair or disastrous results in the divorce context, in our world of estate planning, they lead to really positive outcomes, all right? And so what we're going to do is we're going to pretend I'm married, I've got a spouse, and we're going to buy something. All right. Now, this asset we buy, like I said, it could be anything. It could be a house, a rental property. It doesn't matter. But for the sake of this illustration, we're going to use the simplest asset that I can think of. We're going to do a little bit of math in this PowerPoint. I've checked the math. I had to do that because we're not math guys, especially me. So the math checks out in this illustration, but it's not about the dollar amounts. We're using nice small round numbers to make the presentation easy to follow. I'm going to use the simplest asset that I can think of, just a piece of paper, a share of stock. Okay, so let's go. I'm going to start this thing, and then I'm going to kind of narrate it as we go through. All right, and so that's the little intro. All right, so we've got this, pretend that's the whiteboard. Okay, that's basically what we're doing. We've got a share of stock. All right, and let's say my wife and I pay $100 for that share of stock. That $100 purchase price is what we call our basis. Okay. Basis of $100. Basis is just one of those words the IRS took. We thought we knew what it meant. They gave it a new definition. And in IRS speak, as it says down there at the bottom, you can generally think of your basis as what you paid for something. All right. So now, if we're a married couple in California, community property state, and we paid $100 for something, that means that each of us, husband and wife, has a theoretical $50 interest in that thing. All right. So now, we paid $100. Let's say that thing goes up to $1,000. All right, that'd be a while. Okay, so our fair market. Not now. Yeah. Tesla. All right, so we buy that share of Tesla for $100, goes up to $1,000, and we say, "Wow, awesome! Let's cash out. Let's sell it." And we sell that share of stock. So we got $1,000, right? Wrong. Yeah. Okay. For how long? We got $1,000 for like 2 heartbeats, because the governments are come knocking. They want their piece of the action. They're going to tax us on that transaction. And before they can apply their tax rate to us on that, they need to come up with this thing they call our capital gain. And to come up with one's capital gain is a super simple calculation. All you're going to do is subtract your basis, which you paid for it, from the fair market value, what you're selling it for, and that leads to your capital gain. Oh, okay. Oh, yeah. If it went up to $1,000, if we started as 100, we each had a $50 interest, and it went up to 1,000, we each have a $500 interest. We say, let's sell it. We sell it, and there goes our capital gain calculation. Okay. 1,000 minus 100, our capital gain is $900, and it's that $900 capital gain that we're going to pay taxes on. And what are the taxes? Well, we got two entities you got to worry about, right? The guys back east and the guys up north. So the federal capital gains tax rate is on a long-term capital gain. Got to assume we owned it for a year. So let's say we owned this thing for a year before we sold it, and when we sell it, we have that $900 capital gain. The federal capital gains tax rate for long-term capital gains is 15%. All right, and
what's your high flyer?
Right, if you're a high flyer, they tinkered with it a couple of years ago, and it's a little higher.
You got the net investment income tax implicated too, but we're not going to get into that.
We're just technical.
Yes, too
technical. Keep it simple here. All right. So we got 15% going to the feds on this thing for regular people. And then how much is California going to take? Well, California, we don't really have a capital gains tax. They tax it at your ordinary income tax rate, and those vary too, 13% if you're a high flyer down to, I guess below zero theoretically for some people. But most taxpayers in California, on average, some people were paying about 10%. Okay, so let's say we got 15 going to the feds, 10 going to California. So we're talking about around, for purposes of this exercise, you can factor in a 25% tax hit on that $900 capital gain. All right, now that was the analysis if both my wife and I were alive when we bought the thing and sold it. All right, now, little piece of bad news. One of us, doesn't matter which spouse, that was me at the workshop. I take one for the team. It's more statistically likely, more chivalrous, that the husband dies first. But it could be anybody, but it doesn't matter. In this case, I'll die, and my spouse gets to survive. And now we're going to cross over to the other side there of the whiteboard. And you see these two forms of ownership, joint tenancy, which we talk a lot about at the workshop, and I give a brief intro to. And then community property, our new soon-to-be good friend. All right, now, we're going to do a little compare and contrast analysis as to the capital gains tax treatment between these two forms of ownership. And to keep it fair, we're going to keep the playing field level. We're going to assume that under each scenario, that share of stock was worth $1,000 at the moment of my death. Okay? And let's tackle joint tenancy first because it's the default form of ownership. And now, we bought that thing for $100. All right, went up to $1,000, I died. Now, just because I died, my wife's fiscal perspective on things didn't really change, especially as it relates to her theoretical portion of the basis. Remember how we each had $50 as our theoretical portion of the basis? Well, that didn't change, all right? So that gets carried over here. And in a really rare moment of IRS clarity, they actually have a term for that. It's called her carryover basis. Her basis gets carried over from alive, when we were both alive, to now. It didn't change for her, so it gets carried over here. But see, joint tenancy is a right of survivorship. That's the fundamental principle that really defines what it is. And what that means is if my wife and I own a house together as joint tenants and I die, the right of survivorship means that property is entirely hers. Okay?
No probate.
Right, no probate, no court action, no intervention needed. It really just flows to the surviving spouse, that right of survivorship. And when we're talking about a fiscal asset, more like this share of stock we're talking about, she had her $50 portion of the basis, and if we owned it as joint tenancy when I died and it was worth $1,000, and my theoretical interest in it was $500, for tax purposes, she inherits that $500 portion of mine, and it gets added to her carryover basis. So now you see that 550 number there? That's what they call her adjusted basis. She has an adjusted basis now of 550. All right, so we bought it for 100, titled it as joint tenancy, it went up to 1,000, and I die. And let's say she wants to sell that share of stock the next day. All right, she sells that share of stock for 1,000. She has 1,000 for 2 heartbeats again, but here come the governments knocking at the door. They got to figure out how much they can tax her, and they're going to do that capital gains tax calculation the same way they did before by subtracting her basis from that fair market value of 1,000 that she sold it for. Only this time, we're not dealing with her original $50 or our original $100 basis. We're dealing with her $550 adjusted basis. So this time, she's going to pay tax on $450. All right? Half as much. Amazing, right? Okay, great. But
half as much.
Right, half as much. Half as much tax. That's a good thing. But we can do better. All right? Now, that was joint tenancy. Now, let's just say, for the sake of argument, that 2 little words on that share certificate were different. All right? And instead of it saying the default pairing of words, husband and wife as joint tenants, it said something else that we as Californians have available to us. It said husband and wife as community property. Now, we're going to do the exact same analysis, but you guys are going to see there's two amazing differences in outcome. The first amazing difference in outcome, it comes about simply as a result of the application of tax law. And you guys know, believe it or not, I guess, you know what? This is probably the only year that everybody's actually looking forward to tax time. Because if we're looking forward to tax time, it means we're out of 2020.
Oh, that's
all right. So maybe this crap year we put in the rear view, and then we go, as soon as we get out of this crap year, then we get taxes to look forward. I guess this might be the only year we're ever.
It's an IRS term, right?
Yeah.
Okay. Make sure.
So let's say that we took title to that share of stock that we're talking about here as husband and wife as community property. Now, the thing about IRS stuff, it's just rules driven. You can't go figure out why. So don't ask me why. There is no why to this. But this operation of this tax law, you're going to think of it as tax law magic. Because if we just took title to that share of stock or house or whatever we're talking about, husband and wife as joint tenants, these two amazing outcomes, the first amazing difference in outcome comes about as a result of the application of tax law. And what that means is simply upon the moment of my death, her basis gets magically what they call stepped up to 1,000.
Yep.
Full step up in basis. So regardless of what we bought it for, $100, $50 each, theoretically, it's worth 1,000 when I die. Her basis just magically becomes $1,000. So if she wants to sell it after I've died when it's titled as community property, the tax guys are going to come knock on the door and she's going to say, come on in and calculate away, because she knows when they do that capital gain calculation, they're going to do it the exact same way they did before by subtracting her basis from that fair market value she sold it for. Only this time, we're not dealing with some little wimpy adjusted basis of $550. We're dealing with a fully robust stepped up basis of $1,000. So this time she's going to pay tax on 1,000 minus 1,000, or how much? A big fat red oval. That's supposed to be a zero. It is a zero, but I like to make it more circular. But anyway, it's a big giant red zero. That's not a little less, you guys. That's not stretched out and I picked up at a kid's later on or something. That capital gain is eliminated, completely wiped out. All right.
But you're saying there's a silver lining in debt? Is that what
well, I'm saying, yeah, this is a good news, bad news thing, right? Because you see, this tax treatment is really amazing. That's a great thing. The depressing part about it is it only comes about as a result of somebody dying.
Yes.
Okay. Now, I didn't get into this before, but this technique works for everybody. You don't have to be married to get this step up in basis on that first death. Okay. But it's more than doubly amazing for married people because let's say we bought it for 100, titled as community property, went up to 1,000. She could have sold it for 1,000 and paid no tax, but she doesn't. She holds on to it. And this is where the real advantage for married people comes in, because let's say she holds on to it, and in between the time of my death and her death, that thing goes up in value some more to, let's say, $11,000. All right. Now the fair market value is $11,000. Must be Tesla. All right. Then at the moment of her death, it happens again. It gets a second step up in basis. So those kids who inherit it, that share of stock that way back in the day we paid $100 for, that's now worth $11,000. Kids inherit it with that second step up in basis, and they could sell it for $11,000, and they pay tax on zero. All right, amazing tax treatment. Okay,
it works on everything.
It works on everything. Usually, right now, I tell people at the workshop, I go, "Hey, I'm going to tell you right now, this works on everything. Houses, yes, vacation houses, whatever you want." And even though I say that right now, when I get to this point in the thing, I know somebody's going to say, hey, that's amazing. Does it work on houses? Yes, it works on houses. It works on everything. Okay. It's an amazing, amazing outcome. But I told you there were two amazing differences in outcome. That's the first amazing difference in outcome. That's the wow, we call it at the workshop. All right. That's a wow.
It is a wow.
Thank you. Unsolicited. All right. But what's the second amazing difference in outcome? It's the catch. Dang it. You get the lawyers and tax guys involved, there's always going to be some kind of catch, right? What's the catch? Well, here's the thing. Remember joint tenancy and its nice, smooth little right of survivorship? First one dies, everything just smoothly goes to the survivor. It seems smooth at first, but we talk about it a lot, how that ends up being a dead end that lulls you to sleep. But anyway, it does have the decency of being pretty smooth on that first death. Community property titling now, we know, though, gives us this most awesome tax treatment once if we're single or twice if we're married. But what's the catch? The catch is that community property titling triggers a probate proceeding on death of the first spouse. So before my wife could even sell that thing for the $11,000 and take advantage of that awesome tax treatment, she would, in order to get my name scrubbed off the title and get it in her name only, have to endure a probate proceeding. And you guys, if you know how bad probate is, good on you. It's a head start. We talk a lot about probate, and you got to go check out our evening webinar. We talk a lot about probate. There's discussions of it on our website, obviously, but probate's horrible, must be avoided. So the way to avoid probate, which we talk about at length, the only true legitimate way to defeat probate is to have a living trust. All right, now, we're all, fundamentally greedy people, especially when it comes to good stuff like avoiding probate and beating the IRS and Franchise Tax Board out of taxes. So we really want to have our cake and eat it too in this thing. We want the probate avoidance that the trust delivers on both deaths, but we would really love to tap into this incredible tax treatment once if we're single or twice if we're married. So how are we going to do that? All right, well, the asset should not be titled as joint tenancy or community property. The asset, the share of stock we're talking about, should be titled in our trust. All right? But now, I wrote trust up there. You see trust in giant red letters up there. We write trust there. Now the asset's in the trust, right? The share of stock is titled in the trust the way it should be. And if you have questions about that, we'll answer those or talk about it in another webinar. So we got a position right to avoid the probate. But for us to write trust there, we had to erase community property. And we all kind of impliedly know this. You can only own things one way at a time. All right? But we really want to have our cake and eat it too. So how are we going to get the best of that tax treatment as well as the probate avoidance on both deaths that the trust delivers? Oh, good question. Thought you'd never ask. All right? It's another document. Because you see, when we talk about trusts and estate plans, really the living trust is just one of several documents that comprise what we call your comprehensive integrated estate plan. You got your trust and you got your power of attorney and you got your healthcare directive and you got your will and stuff. But there's another document. And this last document we talk about is what we call the community property agreement. There's different names for it, but we call it community property agreement. And in essence, just a little short 3-pager. But what this 3-page document does, it's super powerful. It says, Dear IRS, Dear Franchise Tax Board, for purposes of tax analysis on death only, treat every asset that's titled in the name of this trust as if it had been titled as community property. So we truly get the best of both worlds. We get the probate avoidance that the trust delivers on both deaths, and we get this awesome tax treatment once if we're single or twice if we're married. All right? And it's all done as a part of your comprehensive integrated estate plan. So that's how it works, you guys. That's how you can defeat capital gains. And as Chris said, it's a good news, bad news thing. It only happens on deaths, but we're going to die anyway eventually. Might as well optimize our tax outcome, and we do, right? So that's the secret sauce right there, you guys. So now let's see. Goes back to that. Now let me see if I can get back to maybe the chat function over here and see. Oh, we got some questions. All right, excellent.
Clients in there. Recognize some names. I'm not going to reveal who you are, people. Don't worry.
Yeah. So, we had a little feedback that somebody said my voice is a little muffled with some echo. Sorry about that. Hope maybe that's self-corrected. I don't know. And then somebody said, I thought this was capital gains today. This was. Thank you. Maybe that came a little early. Thanks for the commentary and the feedback there. Here's a question, a substantive question. Does it work if you own an LLC that owns property? My husband and I have an LLC that owns property. All right.
Okay, so the answer is the LLC will issue a member certificate to prove ownership. And so if that membership certificate is subject to a community property agreement, then you would get a full step up in basis on the first spouse's death and on the second spouse's death if that LLC was titled, either the interest was either titled as community property or preferably in the name of a trust if you have a living trust. So the way we do it when we do living trust for married people and they have an LLC interest is we assign the membership certificate to the trust. And so now the trust owns the LLC. It still provides the asset protection component. So the reason why you have an LLC typically is, there's several, but the main reason why people do that is because they want to have asset protection. In case somebody gets injured at that particular property, they can't take all the assets in the estate. So you don't want to lose that. So, but you don't want to have to go through probate either. So the way we do that is the certificate, the membership certificate is actually issued to the living trust. So you take title in the name of the trust. The trust owns the LLC. That avoids probate. And by having that companion community property agreement, then you get the full step up in basis both times, on the first spouse's death, on the second spouse's death. So that's why we call it a double step up in basis in community property states, is because it happens twice. And we don't want to have, get that outcome and have to still go through a probate process. That's the reason why the trust is by far the best way to hold title when you have an estate that would trigger a probate. You don't want to have to put your family through that, even though you get that wonderful tax outcome. The aggravation associated with a probate would really put a damper on that celebration of the increased basis that would occur. So
yeah, and then Dorothy sent a follow-up question. She said they did their estate plan with us. Need to go back and check to make sure that the LLC has been titled. And there's two ways you can do it, as Chris said. One, you can simply assign your membership in the LLC under the umbrella of your trust. Two, sometimes we have clients who set up their estate plan first, and then they go out and establish an LLC. If that's the scenario, that's the chronology of it, then you can simply have your membership interest issued to you as trustees of your trust. But one way or another, you should have it done. And if you have any doubts in it, I believe if you go into, I think it's tab 8 in your binder, that's where you're going to find things like assignments of business interests and things like that. So Dorothy, if you're looking in your binder, take a look in tab 8. That's where those assignments should be.
Hopefully our voices are better. If you guys are still hearing muffling, we'd like to know that, because we're going to fire somebody for this. I'm joking. Of course I'm joking, but we do want to know that, because we do experience occasional technical difficulties with this technology, and it's not perfect. We're doing our best to make it work, but if it happens enough, we might have to consider moving to a different platform to do the webinars.
Because I have a mask on. That's why my voice is a little muffled.
Sure. Yeah. Is that supposed to be a joke, right?
It's a new style mask.
Okay.
It's totally transparent.
It's a visible mask. Yes, exactly. Dorothy just gave us a compliment. She said, want to repeat that for everybody?
Well, no, you can.
No. Well, okay. So she says we're still as funny as ever. And, this is a serious subject matter. So it's really hard sometimes to maintain a serious nature through the entire presentation, especially for 2.5+ hours when we're doing our full workshop. So we kind of work at a couple of jokes here and there just to make it lighter for people, because we're tackling a really serious subject matter, and very few people like to confront it and want to hear about it. And their kind of mind starts to wander when you think about death. So we try to keep it light and still at the same time educate you. So yeah, the joking part, yeah, it's kind of our trademark, to try to make it more entertaining as possible, as much as it can be. Okay.
We want to be a big buzzkill for you. Yeah, Carol is a client as well, too. And she told us it's a little bit of an echo, maybe the distance from the mic. That might be the case. I don't know. And she says, when can us older clients with paper binders get a PDF file? All you got to do is contact us if you want an electronic version of your documents. And it depends on when you did them. I think it was around 2011 that we started scanning and storing the completed documents of all of our clients. We keep both paper, and from 2011 on, we keep PDF of it. If you're one of those folks from 2011 on, it's really easy for us to send you a PDF of it. If you're from before that time, we have to manually go back in there, expand the pages, scan it, and then send it to you. So it's a little bit of an effort. But if you call and ask, they'll tell you what, you'd say what year you did your trust, and they'll give you either a no problem or a little groan on the other end, and we'll engage in some effort. But yeah, give us a call if you want the 2005. Yeah, that's back in the day. Yeah, so that could be a little project, but if you want it that way, get in the queue. We're getting a lot of requests for things like that these days, and like many businesses, I went to order a part for my bike rack for my car the other day, and they said there's an 8-week back order on before they even process your order, because the bike industry has exploded so much during COVID. We're not at an 8-week period, but we're backed up. We're pretty busy because a lot of people are thinking about this stuff right now. So if you call and you want a PDF of those 2005 documents, Carol, we'll get working on it, but we're not going to promise it like in a day or two. We'll get it out to you for sure. All right.
Okay. David's got a question.
All right.
All right. So David, you live in Northern California. Well, congratulations. You're probably going to get rain before we do down here. We're sitting in our Ventura main office right now. We have 6 total offices in California. They're kind of concentrated on the Central Coast, as far north as San Luis Obispo and Bakersfield, and as far south as the northern fringes of LA County and Valencia. So we do have clients throughout the entire state. And the reason why we have clients throughout the entire state, even though we physically are located only in 6 locations, is because we get referrals from our existing clients, and they want us to help friends and family members who live in other parts of the state, or sometimes our clients will move into the north or other parts of the state. And so we can still accommodate them. It's just that unless you're willing to physically drive to one of our offices, we're going to have to do this by phone or through some type of Zoom interface.
Yeah, we're doing a lot of Zoom
Yeah.
comments now,
And so-
but it's actually cool. I like it. It's a good way to do it. I think it's better than the phone because you get a little face to face.
Right.
And then we can do the way we work it. If you wanted to become a client to work your estate plan through, we could email you the materials. It's called a little workbook. You fill in your information, shoot it back to us, schedule an appointment, whether it's live, phone, Zoom, however you want to do it. And then we'll talk that through, and we'll talk about what's entailed in putting your plan together, have a lot of back and forth, and then we would create draft documents. We'd send them up to you. If you want PDF, we send them PDF. If you want paper, we send them paper. You review those, and we just keep the process rolling. And at some point when you say, okay, these documents are ready to go, how do I sign them? We'll send them up to you for signature ready with a notary that you engage up north, and we can do it remotely. It's really
it's essentially the same experience. The only difference is you're not physically in the same room with us during the process. But in terms of the way that the services are delivered, it's the exact same way. In other words, Paul and I are the ones that conduct the initial interview with our clients to go over that workbook. We're the ones who actually do the drafting, and you're going to be interacting. We take ownership of the project once we meet with our client, and we shepherd you through the entire process from start to finish and beyond, actually. And so we have a lot of clients that have not had any problems whatsoever with the fact that they couldn't physically come into our office. Now, ideally, yeah, you could come in. That'd be great, but it's not necessary at all.
Yeah. So if you guys learned something today and are interested in following up and maybe talking more or checking our website for some more information, or if you want to move forward with engaging us to work on an estate plan, contact us. There's lots of ways to do it. All our contact information is on the materials you have already if you logged into this. So, yeah, we're filibustering here while we can before they outlaw that, I think. Any more questions, come on in. I think we're possibly running out. Anybody got any follow-up questions? Appreciate you guys coming and hanging in today. Like I said, we've got an evening full-blown webinar coming up next week. I want to say Wednesday, but I think check the website for it to be sure. And then, again, we'll be doing another daytime one in a couple weeks as well.
So yeah, and again, they're not putting you on the spot like with questions. Like, this particular plan on it was focused in a very narrow area of capital gains and step up in basis and how that works.
Right. We do, like each daytime when we do a different topic and just drill down pretty deeply.
If you have questions, you can always reach out to us after this presentation concludes. And, one of the features that makes us different than firstly, all attorneys out there, is our policy is never to charge someone for an interaction, like a communication, whether it's by phone or in person or by email. We're not going to. And that's really important because the reason why we do that is we don't want to penalize our clients for reaching out to us or potential clients to determine whether or not they even want to use us to perform any legal services for them. So rather than putting up barriers to communication, our philosophy is let's not penalize them for those interactions because that's going to ultimately lead to more referrals from existing clients who are happy about being able to have us as a resource on a go-forward basis. So our philosophy is establishing long-term relationships with our clients and not penalizing them for reaching out to us. So don't feel like this is the last chance you get a chance, have an opportunity to ask us questions. You're free to do so on a go-forward basis.
I don't know if you
what did I miss?
If you segued from that comment, but Dorothy said thanks. I just referred you to some friends. So
thank you very much. Thank you, Dorothy.
And then just to check the binder, we have a community property agreement signed. Tab 8. Yeah. Keep going. Oh yes.
Yeah. As opposed to
Yeah.
That was yeah.
And then if you want to look, okay, I was a little wrong on my intel on the tab numbers. Tab 8 is going to contain your community property agreement. Awesome that you got that, and that's a yay. That's a wow. Look in tab 9 to see if there's the assignments of your LLC interest into the trust as well. That's where they would be, tab 9. Okay. So otherwise, you guys, thanks for hanging in and appreciate you stopping by. Hit our website for some more info, and we look forward to seeing you at our next presentation.
Thanks to you, everybody. Be safe.
Thanks. Yeah, take care.